question from Rekha Kumar, does all property need to be in the trust? The answer is no, it doesn't have to be, but maybe you can explain what a pour over will is and how that might protect somebody who forgets or might set up you can talk maybe a little bit about a Hegstead petition. What happens if assets are left out of the trust? Can they be in the trust?
Okay, so not all assets have to be in a trust. You just want to really understand what the intention is. So, for example, you can have a bank account and you could just decide that that bank account is going to go to the surviving spouse, or you might have an account with $100,000 in it. That's really like your money that you hold for your parents. So you could designate whoever you want as the beneficiary. If you've got financial accounts with beneficiary designations, that actually supersedes the trust. So you want to be really careful, because sometimes people are like, oh, well, I have this much money. And then when you really dig deep, you're like, well, yeah, but you have these people as the beneficiary on this account. Well, yeah, no, it has to be those people. This money came from here, or this is my intention. So then you don't want to put it under the trust. So you know, it's not as simple, people think it's not always as simple as it seems. Like, let me create a trust, let me put it all in there. You don't necessarily always want to do that. I personally, every attorney is different. I personally never suggest my clients to put their IRAs and 401ks under a trust. Beneficiary designated. You can't title it into the trust. There are trusts that you can create for the purposes of IRAs and 401ks, but typically we just guide clients on how to beneficiary designate that. So you could have your house be in a trust for your kids, but leave a $100,000 account to your boyfriend or your mate or whoever. So you could carve, it's like think of it as a pie that you own, and you can carve it out. This goes in the trust, this doesn't go in the trust, and so on. Like, you don't go and I don't change the title to all my clients' cars and put it under their trust. But there's a document that I create that says, if I die, my brother could easily sign the DMV documents and paperwork and either transfer it to my son or daughter, or sell it, And those are issues. I mean, I get the ones that really kind of frustrate me are when they don't have a lot of assets, they have a car, there's a bank account, and there's no beneficiary and they don't know what to do. Those are really tough, because then it becomes cost benefit. Like, it's not even worth it for them to pay us to do it. So I'm like guiding them on the phone, trying to tell them what to do. And that actually is a more time zap than if they just hired us to do the work, but it doesn't make sense,